I'm here on August 1st at the KEI office with Krista Cox, who's the staff attorney for KEI, and I'm here to ask her questions about the TPP negotiations. And one thing in particular I'm going to focus on right now, and that has to do with the provisions in the TPP which have to do with the enforcement of patent rights against doctors or other medical professions. Krista, can you explain what the TPP proposes, as far as we know, as regards this issue, and why we should care about it?
Based on leaked text from February of 2011, the U.S. proposed text that would require parties to the TPP to provide patents for diagnostic methods, therapeutic methods, and surgical methods. And the reason that we care about this is that in the United States, we don't enforce surgical patents against medical practitioners. So the TPP could change this.
Have you? Can you explain what part of U.S. law is that deals with this issue?
Sure. Under the Patent Act in the United States, there's a section on limitation on damages and remedies, and there's a specific provision under 35 U.S.C. 287 that limits the enforcement of surgical patents against medical practitioners.
And does the TPP, as far as you know, permit an exception similar to the one that's in the United States statute?
Based on the leaked text that we've seen, there is no exception to the enforcement of patents against surgeons.
So if the TPP went through with the U.S. proposal and it was enforced against the United States would then have to amend its patent law to permit patent owners to sue doctors for performing patented surgical procedures.
It would be, in order to be in compliance with the text of the TPP, and if it did not amend its patent laws, it would be subject to dispute resolution.
Have you brought this up with the U.S. trade officials, pointing out that there's a provision in the U.S. law which would be banned under the TPP patent provisions, and that provision is an important provision as far as being able to have a doctor perform any procedure they think is necessary on a patient?
I've brought this up with Perbier, who's the lead IP negotiator for the White House Trade Office. We've also brought this up with various federal agencies and mentioned that the importance of this provision, and how the American Medical Association was the one that lobbied to have this provision put into U.S. law.
Have you brought this up with members of Congress, or I should say members of Congress or their staff that follow trade negotiations?
Yes, when we met with various Senate offices, we have brought up this specific point because we think it's very relevant to the United States. For example, in meeting with staffers from Senator Bingham's office or Senator Feinstein's office, we pointed out this inconsistency between the U.S. proposal and current U.S. law.
Do you know if any member of Congress has written USTR to complain about the fact that USTR is trying to negotiate away this exception for surgeons?
To my knowledge, there has not been a member of Congress who has written specifically on this issue to USTR.
And what is the response you get when you talk to USTR, which is the lead trade agency on the TPP negotiation? What's the response they give you as to why their text would eliminate this exception in U.S. law?
Well, we usually get one of two responses when we talk to the United States Trade Representative Office. The first response is, we do not comment on leaked text. If they do give us an actual response on this issue, the response we usually get is, well, you don't know that that's what we really want. This could just be a negotiating stance.
So just to be clear about this, what one argument is that you get from the U.S. government and the Obama administration is they're putting something in the law that's inconsistent with our own law and that we don't want to happen, so that some foreign country will ask in the negotiation to have it removed. Is that correct?
Exactly. They are putting in text that they don't actually want because they know that other parties will have to push back on that and perhaps negotiate away other things. In previous trade agreements between the United States and other parties, the United States has not come out with final text that would require the patent patenting of surgical methods. For example, in the Peru-US FTA, there was a specific carve-out for surgical methods. Same with the Australia-US FTA. The Chile and Singapore FTAs with the United States remain silent on this issue.
Thank you, Krista. Is there anything you'd like to add before we conclude the interview?
Nope, that's it.
Thank you very much.
Thank you.